SJC-12686 AFVDF.
Chief Justice Ireland is here.
I can't see him. Where is he? Left, to left.
I see him.
You do, okay. Apparently Chief Justice Ireland is here, but he's, well, there he is. Okay. There were reports that Chief Justice Ireland was here. We welcome you. And it shows that you can run, but you cannot hide, Chief Justice Ireland.
You fit him up here.
All right, sir, you may proceed. You've got 10 minutes, sir.
Thank you. So basically, my argument is that the county court should have granted my petition for 211 Section 3 and Section 4 relief, seeking to invoke the superintendent's power and transfer my case out of the Orange District Court to a court with appellate jurisdiction, where it's been the precedent of this court to grant such relief if the petitioner shows A, that a right's been violated, and B, there is no adequate remedy. As to the rights violated, first, my due process rights were violated by the lower court when it issued a 258E order at the end of a 209A hearing. It has been the precedent set by this court that restraining order hearings cannot violate the due process rights of defendants. In a case directly on point, the appeals court held that issuing a 258E order at the end of a 209A order violates due process. It is indisputable that after successfully arguing against the 209A order, the lower court judge issued a 258E order, where the judge openly admits to this in his memorandum. Thus, this unconstitutional order is thereby void. My right to free speech was also violated by the lower court. It is clear that the lower court intended to regulate my speech with this 258E order, where it did not only order me not to contact the plaintiff, but also not to share my opinions about her. The precedent of this court is clear that 258E orders can legally only regulate unprotected speech, that is, fighting words and true threats. The lower court's findings are contrary to this precedent. According to the lower court judge, he issued this order because I told my children that I was innocent of any crimes against their mother and that she lied about me. The judge also cited that what he called a veiled threat to support his findings, which was taken out of context. In context, there was no threat at all, nor did it have anything to do with the plaintiff. To be clear, all of my opinions about the plaintiff were directed to my children, not to the plaintiff. This court should also take note that I was granted unrestricted access to my children by the Worcester Probate Court. Therefore, it is completely within my rights to share my opinions about the plaintiff with my children. The lower court has misconstrued this court's findings in Commonwealth v. Welch to support its decision. The lower court found that because the plaintiff somehow suffered emotional stress by me telling my children I was innocent, that a 258E order was appropriate, and cited Welch in support thereof. However, the Welch court was clear that the substantial stress element was closely tailored to punish only fighting words, and that any attempt to punish speech not within the fighting words doctrine would violate the U.S. Constitution. There were no fighting words. Not only was my speech not face-to-face, it was not even directed to the plaintiff. Turning to adequate remedy. Indeed, I should have had another remedy available. But because the clerk refuses to transmit the record to the appeals court, I don't. To be clear, I did everything possible to have my appeal docketed in the appeals court. First, I filed a proper and timely notice of appeal. In addition to the notice of appeal, I also sent letters to the clerk of the appeals court and to the chief justice of the trial court, expressing my intent to have my appeal properly docketed in the appeals court. However, the lower court clerk refuses to transmit the record to the appeals court, where the clerk erroneously believes that the appeal has been resolved. The opinion of the county court is that I should continue to file late notices of appeal. Respectfully, this would be meaningless, since even after filing a proper and timely notice of appeal, the clerk refused to transmit the record. If the chief justice of the trial court can't get the clerk to transmit the record, I just don't see how I could do it by just continuing filing notice of appeals.
Excuse me, sir.
Yes.
Yes. Can you tell us why does the clerk give you any reasons?
She did not, but she gave it got transferred from the Chief Justice to the executive branch of the trial court. And she told them that my appeal had been resolved because in the interim, after I filed my motion to vacate, I filed a motion from the single justice asking to compel the court to rule on it because he was taking a long time to rule on it. After he ruled on it, that motion became moot. So the clerk told the executive office that it had been resolved by the motion to compel being moot. And that's all I know. It's in the record. Only thing I have is the letter from the executive office is where they tell me that. It's in the record appendix.
Did you file a motion to file the appeal late?
I did not because I filed the timely notice of appeal. As soon as the judge denied my motion, I filed the timely notice of appeal.
Uh-huh. Did you follow the, I thought Justice Budd in her single justice order gave you like a roadmap of what to do.
Yes.
And did you do what she asked you to do? Did you do what she said was available to do?
I appealed the decision after that because I didn't know how to get to court. At this point, I had already wrote to the Chief Justice of the trial court trying to get into the appeals court. And I just didn't know how. I thought maybe the single justice misunderstood my motion because I had already filed the proper timely notice of appeal. So I didn't know that filing late notice of appeal when I had already filed a timely one. I didn't know how to necessarily do that or to word that. I had already did everything proper, and just the clerk, I don't know, wouldn't transmit my case. So all I was seeking basically was to get this transferred out of the Orange Court. So I didn't, based on the decision, I didn't know how to proceed any further in the Orange District Court by filing, by filing late notice of appeals when I'd already filed a timely one.
Okay, anything else you wish to say, sir?
That's pretty much it. I'm just asking that this court, reverse the decision, and find that the clerk's actions gave me no other remedy. And, to transfer the case and to rule on the merits of this case. It's been a long time, and I feel that my rights have been violated, and all I'm looking to do is have an appellate court review this. Just can't seem to get it done, so thank you very much.
Okay, thank you, sir.
Thank you. Can he see us? Can he see us?